A short time from now, Judge Amy Coney Barrett will all but certainly be confirmed and sworn in as the 9th Justice on the U.S. Supreme Court, just 30 days after her nomination and 8 days before voting ends in the presidential election. Of course, the breakneck speed and timing of the process has gotten a lot of criticism from Democrats, but it's just one of many norms the Trump administration has upended since he took office. Who can forget his endless undermining and manipulation of the Justice Department, or his administration's refusal to comply with congressional subpoenas issued for multiple White House staffers? And then, of course, there are still those mystery tax returns. Those are just some of the many reasons why two top lawyers from the Obama and Bush administrations have teamed up to offer more than 50 proposals for reform, which would address issues of presidential violations of norms and laws, as seen in the Trump administration and many prior. They address issues from foreign influence to Justice Department politicization, from war powers to nuclear weapons and more, all of which are laid out in their terrific new book. It's called After Trump, Reconstructing the Presidency. I'm joined now by the authors, former White House counsel to Barack Obama, Bob Bauer, and Jack Goldsmith. Jack is former head of the Office of Legal Counsel under George W. Bush. Bob is now a professor and distinguished scholar in residence at NYU School of Law, co-director of its Legislative and Regulatory Process Clinic. Jack is a professor at Harvard Law, co-founder of the blog Lawfare, and senior fellow at the Hoover Institution. Gentlemen, congratulations on the book, and thanks for joining me.
Thank you for having us.
So, as I said, dozens of important reforms. I wish you could do one of those base closing things where it's just up or down, but obviously that's not what's going to happen here. I want to pick a couple, if I may, of currently hot issues that Americans are thinking about and see what you suggested be done to address them. First, and I'm assuming this is yours, Jack, because of the Justice Department, Trump has demanded that his Attorney General indict his political enemies. You have a chapter on Justice Department independence. What would you do about that?
So that's a hard one because the president is in charge of the executive branch. And if he has an attorney general that wants to carry out his wish, that's difficult to do. We basically propose, first of all, let me say that we propose a lot of different things to get at the independence problem. And on that one in particular, we proposed simply to clarify that the Justice Department people who work there are subject to the obstruction of justice statute, something that's not well known, and also to clarify that something that's also not well known, that the department has a strong norm against politicization. But the reforms really go beyond that. We also, I think the most important reform that gets at that problem is to make clear that Congress has to pass a law that the president himself can be subject to obstruction of justice, criminal obstruction of justice. This is not clear now. It was a point of contention in the Mueller report. And that's probably the single most consequential reform that would put a check on that.
Bob, can I move to another one? The failure to disclose tax returns, which I think has been an oft-discussed topic. It was brought up in both debates. What do you do about that?
Congress can certainly enact a statute compelling presidents and presidential candidates, nominees to the major parties or independent candidates who are on the ballots of enough states to win 270 electoral votes and be elected to the presidency, could require that class of candidates to produce their tax returns. And the norm having failed under Trump, it appears that the time has come to do that, to take what was once a norm of voluntary tax disclosure and convert it into a legal requirement that presidential candidates have to comply with. I would also just add really quickly that that is one of a number of reforms that are needed to address financial conflicts of interest. We've also seen in this administration a president who essentially wants to run the country and be concurrently involved in running and promoting a business. This has revealed some really significant gaps in our regulation of presidential financial conflict of interest, and we propose reforms to close that gap.
Who wants to take a third one that I think a lot of people are concerned about, namely following in the wake of pardons or commutations that appear to most people to have been politically motivated, that the president may decide if he loses on November 3rd or thereafter that he pardoned himself. My understanding was that the Constitution gives virtually unlimited authority to the president with no restrictions to pardon, but you guys seem to think that Congress could put some constraints on that. Who wants to take that one?
I'll take that one.
Thank you, Jack. I was worried no one was going to take that one, but go ahead, Jack.
Thank you, Professor. So you're absolutely right you're mostly right that the pardon power is among the broadest in the Constitution, the most difficult to regulate. It's sometimes referred to as absolute, but that's not true. And it seems pretty clear that Congress could pass a law that would not stop a president from giving a pardon in exchange for a bribe or to obstruct justice. He can't stop the president from doing that. But you can criminalize that act and criminalize that separate act and make it a crime either to obstruct justice or to take a bribe. And so there's a lot of concern about what Trump has done and might do in the interim if he loses the election. But that is at the top of the list of concerns. And the other one, of course, is the self-pardon that you mentioned. That one is completely unclear. Scholars, there's just no guidance in court cases. There's a takeaway sentence in a Justice Department opinion. We think Congress can weigh in on that, but it can't decide the issue.
You know, Bob, when I'm reading this book, and I became borderline obsessed with these reforms, by the way, to the point of almost an illness. I have to be candid. But as I'm reading them, first of all, I should make clear to people, this is not some anti-Trump screed on your behalf. You go out of your way to make clear that prior presidents often were doing some of the same things that he's done. You give the history, but I think you'd both agree that it's Trump inspired, that he sort of elevated it to a level that hasn't gone before. So, Bob, directed at you, the concern I had is you craft reforms based on the norm and law abusing, for lack of a better expression, of this president. But it seems to me that they would only be effective against the president who didn't act like Donald Trump. That if you're Donald Trump and don't worry about breaking laws, you don't worry about breaking norms, you don't worry about congressional oversight because you just don't comply with it, how does this fix a Trump 2.0?
Our view is that where there is not a law and could be a law by reform, that it does operate to constrain presidents. It is true that Trump has repeatedly manifested indifference to law, but there are many instances in which it's clear that the existence of laws have in fact constrained him. And there are norms, in fact, even though he has resisted them mightily, that have constrained him. So we believe that where the law can be strengthened, loopholes can be plugged, fresh constraints can be crafted, and norms can be invigorated, the next Trump who comes along will at least have fewer weaknesses to exploit, fewer fissures to exploit in the overall structure against conflict of interest.
You know, in this, I hope you're not offended if I call you an odd couple, but that's one of the reasons why I think this book is so powerful, because you are an odd couple. But I know it's clear that the one issue on which you both disagreed is what should happen to a law-violating president after he or she someday leaves office. Bob, I think it's fair to say that you believe you both believe he's subject to a criminal prosecution. You say go for it. You don't deny, Jack, that he could be prosecuted. You just say as a matter of pragmatism, it's a bad idea. Starting with you, Jack, could you give me a 30-second summary of why, if thanks to the office you used to work in, a president can be investigated but not prosecuted while in office, why should he get, I think you referred to, Bob, as a get-out-of-jail-free card after the fact as well?
I don't think he should get a get-out-of-jail-free card. I think he's still subject to prosecution for his pre-presidential acts. There are two different ones going on now in New York, in the federal courts and the state courts.
I'm talking about his during presidential
acts as president. I don't think that the president should be immune. I think in this case that it's a mistake for the country as a pragmatic matter to try to prosecute Trump. It's not clear that he's violated any laws that he can actually be prosecuted under. The process of doing that would be novel in American history. One administration investigating the acts of a prior one for criminality. I think it would maintain the circus that's been going on in Washington and make it hard for the Justice Department to kind of move forward with the appearance of independence and impartiality. And I think it would just be bad for the country on balance. It's not that I understand Bob's argument. I mean, it's a powerful argument.
Why is he wrong, Bob? Except where he says he understands your argument.
I thought he spoke very accurately on that point. I understand his argument as well, and I think Jack's argument is nuanced and responsible. It is an area where we ultimately do disagree in this respect. I really dislike the OLC current opinions that immunize the president from prosecution while in office. I don't think they were well reasoned. I think they created all sorts of trouble. But I also worry about the establishment of a norm that's overread to immunize a president in the name of national healing or avoiding political conflict after the election. I do agree entirely that the process by which that investigation and the determination of prosecution is made has to be a responsible one, guided by really good judgment. But I don't believe, taking the Gerald Ford Richard Nixon example, that we should assume that on balance it's just better to have presidents pardoned so that the nation can move forward. I think we do have to have accountability so that the president isn't viewed as being above the law.
We only have a minute left. Can I quickly bring up a norm that's being violated that is not in your book? Bob, starting with you. How do we ensure going forward that Supreme Court nominations do not proceed once the people of America are already voting?
There's really actually no way to do it. The only way to avert this kind of sort of, if you will, constitutional bloodshed over Supreme Court appointments is to potentially look at reforms like term limiting Supreme Court justices so that every president is able to appoint them.
How about you, Jack?
Yeah, I'm afraid I disagree with you that there's a norm being violated here. It's clearly constitutional. It's a clearly constitutional practice. To make the reform you want, you'd have to have a constitutional amendment, and it's not clear what it would look like. I agree with Bob that there's clearly something very wrong with the confirmation process. It clearly needs to be studied and reformed in some sense, because the confirmation process has just gotten to be very, very destructive for the courts and the rest of the nation. But I don't think there's an easy fix for it.
Maybe you'll let me write that chapter in your next book, gentlemen. Jack and Bob,
Absolutely.
The book is terrific. I hope everybody reads it. A pleasure to see you both. Thanks so much for your
Great
time.
to see you.
so
Thank you
much.
very much.